Good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Thursday, May 5th, May 14th, 2026 at 2:50 in the afternoon. And so we're back from the floor to continue our discussions on 71. Rick, if you could take us from the place we stopped from and continue on.
All right, so Rick Sagal with the Office of Legislative Counsel. I have us on page 16 at the end of the definitions. I think there are two that we didn't get to. So we have third party three, we have third party trade secret, which is a reference to Title IX and the VSA, and then victim services organization.
Victim services is Vermont exemptions.
Okay, the applicability. So the thresholds, remember, this is what the bill would apply to unless you're exempt. So if you control a process, the personal data of not fewer than 35,000 consumers, meaning Vermont residents, that excludes personal data controlled or processed solely for the purpose of completing a payment transaction. Or if you control or process consumer sensitive data, any number, one or more. And three, sold the personal data of consumers, one or more, would be meaning that you meet the threshold.
So I'm gonna have a problem with that section alone. The sensitive data pushes you over no matter what the amount.
This is an exact match of Connecticut 2025.
Yep.
Study.
I get that. I would still have a problem. I think I've been on the record saying that before. Been on the record saying a lot.
Okay, also health data. Section 2415K, which is at the very bottom, and the provisions that concern consumer health data and consumer health data controllers apply to a person that conducts business in the state or a person that produces products or services that are targeted to residents of the state. Controlling law, I mentioned this was added to clarify if there's any confusion between kids code, this, data brokers, federal law, unless federal law preempts this, but mostly in state law provisions that the provision with the most privacy would control. Then we have the exemptions. So it does not apply to a federal, state, tribal, or local government entity or instrumentality of the state. Does everyone know? Comfortable with that? Okay. Two, ABC are related to hybrid entities and HIPAA. So a covered entity that is not a hybrid entity, any healthcare component of a hybrid entity, or a business associate.
I'm not sure that have we ever explained what the derivation of this was? We had a conversation with some of the folks representing healthcare providers and health facilities around if the committee wanted to include an exemption. What would that look like? This was one piece of it in terms of covered entities. And I thought about it. I talked to Todd a little bit in terms of whether it is enforceable. If it's not, if these entities don't maintain and protect their records in accordance with HIPAA. And he said to me, but he had to look a little bit more into it, that it would be enforceable by the Attorney General's office. Now, I mean, that was comfortable, but I'd like to get him on the record to do that. And the second item in that meeting that came out of that meeting had to do with medical practices that are not covered by HIPAA because they don't like to do the business with health insurance companies. So they don't. And so this is sort of direct to consumer kind of thing, patient kind of thing. There was some language that, please correct me if I'm wrong. I think there was some language that was offered to us around dealing with those folks. And to me, that makes a little bit of sense because if we're exempting, especially some of these large folks from the bill because we think that the protections under HIPAA are sufficient. It's my sort of construct in my way that my mind works that it might be appropriate for these other entities. The concern I had was whether or not they had equally, protective construct. And they forwarded to us some language that I can actually circulate, but that had to do with an exemption for these folks. As long as they maintain all protected health information in accordance with not only HIPAA, but there's a provision in Vermont as well. The two issues that I had with what they proposed to us, one is that I really thought it would be appropriate to have some sort of patient threshold cap on that. I didn't want, a lot larger entities to try to take advantage of that. I don't know how they would, but if you lower the patient threshold number, it's less likely. And then I also asked Todd, can you enforce that if these practices don't maintain, their data, their personal health information in accordance with HIPAA constructs? Would the Attorney General be able to say, well, you're no longer meeting the exemption, so that would need to be enforced in terms of the bigger bill. So that's what I'm thinking of. That's just the way I'm thinking. I don't actually know, what everybody else thinks about that, but I have a draft of that if people want to see it, but otherwise, could just talk about it in general terms, decide whether we want to think about that or not.
We have some language. Of other language as well.
In this draft, nothing.
It's not, but yeah, I know there's language that's been worked on.
Yeah, I took that language that was worked on and I included that patient cap. And then I had a sentence about making sure the AG could enforce it. Maybe that's not necessary. Maybe Todd can say, you don't need that because I would anyway. And I told him we might need, if we're going to pursue this, that I would like to see that kind of on the record, either writing or whatever you want to do.
That's something that our folks in the healthcare field.
I'll let them speak for themselves, but I think they're not comfortable with the patient threshold limit. I think that's, I don't want to speak, but I think that's the main concern.
I think there's other language that they're comfortable with. We can both make a choice which way to go.
Absolutely. Okay. Just so I don't have to carry my paper around. Can I circulate? Wish it.
Sure.
I'm not
By the way, we're paperless.
What's that?
We're paperless committee, but
Yeah, well, I don't belong here.
We're both going to email that to me because I am paperless. So if you email it to me, your language, yeah.
Yeah, I got it. You don't even want the paper.
no.
There's
paperless.
Yeah, are there enough copies for everybody? No, see, I'll take the extra copy. Thank you. I didn't want to take one from someone else. Okay. Okay, so moving along to subdivision 3. I'm not going to read all these. I read through the bill, but again, I will slow down for each one. These are your health, government research, HIPAA related exemptions. As I mentioned before, I'm not the best person to explain what's happening here. That would be Jen Carby, who was here earlier. If you have questions, you can also email me or her for more information about each of these exemptions. So going past 5, public health activities. 6, identifying a consumer on uses of human research. These are pretty standard exemptions from my understanding. Substance use disorder, patient records, patient safety work product. 9, information documents created for the Healthcare Quality Improvement Act, 1986. 10, a little bit different, talking about emergency notification. 11, activity involving collecting, maintaining, disclosing, selling, communicating, or using information for the purpose of evaluating a consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living, if done strictly in accordance with the Fair Credit Reporting Act, as long as it's by a consumer reporting agency, a person who furnishes the information to a consumer reporting agency, or a person who uses a consumer report. Information collected, processed, sold, or disclosed under and in accordance with the following laws and regulations. The Driver's Privacy Protection Act. Data that is subject to FERPA. Data subject to the Airline Deregulation Act. Data.
Are we still pointing out whether or not this is an S71?
So I emailed out a link that shows you if you feel free to have that pulled up while I'm talking, and the exemptions are pretty different. And some of that is because S71 is passed by the Senate, it's structured a little bit differently, how they structure the exemptions, but the exemptions are fairly different between the two bills.
Just add on to that. So, when we were going back to 2024, trying to from hearing from state AGs, Connecticut's own AGs, as far as trying to move from entity level exemptions, which anything that has been a copy of Virginia has been generally an entity level exemption, to data level exemptions, which we talked a lot about with the 211 data broker bill, of trying to move from entity level to data level to like how is the data used in specific cases sometimes. So these are generally trying to get at data level exemptions, largely craft. I think Oregon was the base of most of because Connecticut was entity level. Other states started moving towards data level. So I think Oregon was the state that had the start of kind of like moving to data level. And then a lot of these are like very much were conversations from, not a lot of these, but I would say like a lot of these are translations from the entity level of what's in most of them. And then there are certain ones like the Fair Credit Reporting Act one, and certain the Gramm-Leach-Bliley related ones, some of the healthcare related ones that were very much a back and forth with those industries to try to get to a point that they felt like it was going to let them do the kind of like legal, especially like legal business requirements and things like that they had to not interrupt commerce and things like that. So yeah, I mean, it's so even like the 14, a state or federally chartered bank or credit union, that came from working with the credit unions and the bank and financial lobbyists and their clients. So each one, I would say I won't be able to say like this is in such and such every single state, or this is in Connecticut 22 versus 2025, or this is something we did with lobbyists in Vermont, or whatever. Like we can, if you have specific questions and concerns about each one, but it's not a situation where I'm going to be like Vermont or Connecticut 22, Connecticut 25, Vermont, like blah blah blah. I don't even have that documented on here.
I would say I'm going through Connecticut's bill. It's just, it's formatted very different. It's hard, it's a really difficult, like you'd have to. So I've been going back and forth between their law and our bill. Formatting is not even close to the same, so.
And a lot of these are the interplay, I think Rick mentioned like the interplay between, especially like when we were talking about the financial and banking entities, we had that whole chart of every single Vermont's kind of like law that related to privacy, and then all of the federal laws, and then Maria Royal charted out every single right in 121. And then we basically looked at it for the loopholes in the coverage and determined that like the state and federal combination of these things and the exemptions were okay. We didn't do that for things like HIPAA. But generally a lot of the exemptions list is because there's an existing state and or federal law that is regulating these things. So we're exempting them because they're already in a regulated space.
Right.
Yeah, that's really the like, yeah, that's the key. I should have said that at the first, but that is generally the idea of the exemptions is they're already covered and regulated when it comes to privacy.
So I am on D, data subject to the Farm Credit Act. 13, non-public personal information processed by a financial institution subject to Gramm-Leach-Bliley, a state or federally chartered bank or credit union or an affiliate, a person regulated pursuant to AVSA Part 3, that's insurance. A third-party administrator under Vermont law.
Yeah, so that's something I was flagging. No, the TPAs,
Okay.
because going back to, Monique was talking about, these entities that were exempting have some other construct to protect private and personal information. I looked at the rule. I need to confirm with DFR, but my brief review of the TPA rule didn't seem to contain any protections for personal data. And I asked Joe earlier this week, I think, and he said he needed to check someone, but he didn't believe that that was the case either. I don't say necessarily that there's something. I'd like to see some structure for protecting personal data. TPA is a little tricky because you got ERISA issues that are implicated. Maybe, I don't know. But I was just uncomfortable having a broad exclusion that didn't have some substitute protection.
$17. Just personal data of a victim or witness of child abuse, domestic violence. 18, a nonprofit established to detect and prevent fraudulent acts in connection with insurance. Information 19 that is processed for purpose of compliance, enrollment, or degree verification or research services by a nonprofit established to provide enrollment data services to post-secondary schools. Non-commercial activity of various entities. '21, data processed or maintained in the course of an individual applying to employed by or acting as an agent or independent contractor of a controller, processor, consumer health data controller, or third party to the extent that it's collected and used within the context as the emergency contact information of a consumer pursuant to the subchapter. That is necessary to retain to administer benefits for another individual relating to the individual who is the subject of the information. And we had B, speaking about COPA, that controllers, processors, and consumer health data controllers that comply with the verifiable parental consent requirements of COPA shall be deemed compliant with any obligation to obtain consent pursuant to the subchapter. So should we have exemptions? I guess I'm wondering how we're going to do this. Each going to come back on tomorrow or?
Well, I want people to speak up now.
Okay. Consumer personal data rights, 2415D. This is some Connecticut language here in the turquoise. Connecticut 2025 language. Want to be clear about that.
I'm sorry. Can I go back to 21C? And I'm not sure I understand this. Data, this is the exemption section,
Mhm.
and data processor will maintain that it's necessary to retain or administer benefits for another individual relating to the individual who's subject to the information pursuant to subdivision 2, which I think is what's in here is the HIPAA.
Yes, that might need to be corrected. That is 2 is the covered entity. I think I need to double check that cross reference.
I would think that, I don't know. I didn't do enough research on this, but.
Well, because 2 was added in this draft, right?
Oh, I see.
So that's what I think it might be 3.
Oh. In any event,
Yeah.
I wanted to make sure that those folks, they sound almost like a business associate, but I'm not sure.
I'll double check.
So I don't know whether that's necessary. Or if it is necessary, I don't understand why.
That would pertain to 2A, B, and C.
Right, so I think it's incorrect. I think it's an incorrect reference. Yep, because these were added and they were put into this. I think,
Oh,
see what I'm saying?
yeah,
Before.
I'm sorry.
No, you found.
No, it's not a mistake.
You found a mistake. No need to apologize. So I think this 3 patient identifying information was 2, and that's what it was referring to. But let me double check.
Oh, okay.
Yeah.
And yeah, I can't remember what that federal reference is.
Yeah, I don't know.
And it's just to make sure that there's some types and construct applicable to this.
Okay. So consumer personal data rights. Again, I've read through it. I won't read it word for word, but this is the consumer shall have a right to, 1 through, I think, 6, confirm whether or not a controller is processing their data and access it. Connecticut added that additional inferences about the consumer. Slowly go to 2. Correct inaccuracies about your data. Delete your data unless it's required by law.
I think 3 is from, I gotta double check this, but I think 3 is from 1.3 from our, I think this might be Vermont specific, so, but I gotta double check this.
What would other states, how would they differ from that? Okay, generally very curious how they would change that language. 4, obtain a copy of your data in a portable and, to the extent feasible, readily usable format that allows you to transmit the data to another controller.
Connecticut updated this one between their 2022 version and their 2025 version.
Pretty similar to that.
It's very, I
Senate.
think it's the third party piece, I'm pretty sure. I could be wrong.
Looks like S31.
Okay, okay.
Okay, 5, obtain from the controller a list of the third parties to which controller has sold their data. Or if they don't maintain a list, then a list of third parties to which such controller has sold personal data, provided the controller shall not be required to reveal any trade secret. 6, opt out of the processing of the personal data for purposes of targeted advertising, the sale of personal data, and profiling and furtherance of any automated decisions that produce legally or legal or similarly significant effects concerning the consumer.
This is just a reminder, I think we said this before. Similarly significant effects with have been described as health insurance. What was the?
Yeah, what did I say? It's things that like aren't necessarily protected as like classes you discriminate against, but could be like discriminatory type of, that's just an example. I don't know if that's like, that was just an example, Jonathan.
I'm sorry. Yeah, I'm not trying to be. I think it's defined on page 5. That's the reminder that we already talked about. It's defined.
Yes, yeah. And this is an area that I believe Connecticut updated from 2022 to 2025. In C, there's they had solely automated decisions and they updated it to any.
Okay, 7, if the consumer's personal data was processed for profiling, and if feasible, A, question the result of such profiling, B, informed of the reason that such profiling resulted in such decision, review the consumer's personal data that was processed for the purposes of such profiling, and if it concerned housing, take into account the nature of the personal data and the purposes for which such personal data were processed, allow them to correct any incorrect personal data, and have it reevaluated based on the corrected data.
And that's Connecticut 2025.
Can you scroll up, and go back to B, or the opt-out provision. Look at subsection B. And so as passed, it says, except for provided in subsection 2420, which has a pretty large section in there. Is there a reason why that was removed?
2420, the section heading.
It's controller duties, sale of personal data, third parties notice, and disclosure to consumers, consumer opt-out, subsection B, which is subsection B, which is subsection A of this section, shall not be construed to require a controller to provide a product or service that requires the personal data of the consumer that controller does not collect or maintain, or prohibit a controller from offering a different price, rate, level, do I need to keep going? Or, okay. Or selection of goods or services to the consumer, including offering goods or services for no fee if the offering is in connection with the consumer's voluntary participation in a bona fide loyalty, rewards, premium features, discounts, or club card program.
Where's that from me?
So that's from us as passed. So this section right here, after the sale of personal data, it says, except for, no, go back.
Except this, private, no,
Except as provided in subsection 2420 of this title.
that's it.
Correct. But I don't know what the impact is.
Okay, and I didn't know the longer provision, where did that come?
That came from the Senate as well. So that's on page 24 of the Senate bill,
Oh, okay.
and it's subsection B, which it says subsection A of this section shall not be construed
I see. Okay, I understand. Thank you.
to require a controller to provide a product. So if I understand that correctly, that means that sale of personal data, except as provided in this subsection. I mean, it's not confusing at all. Subsection.
So I have it pulled up here. Making people dizzy probably. 2420B. I'd want to look at Connecticut's updates. This is basically a carbon copy of Connecticut 2022. So I want to see if that was a mistake. That seems like it doesn't connect, but something I can look at and figure out what the restriction's supposed to be.
But I'm wondering if it's you can opt out of the sale, but can't be construed to require a controller. So does that mean without that, you can't deny somebody access? I mean,
So page 41 of our bill, starting at line 9, says the consumer's decision to opt out of any processing of the consumer's personal data, purpose of targeted advertising, or any sale of the data, ... conflicts with the consumer's existing controller-specific privacy setting or voluntary participation in a bona fide loyalty rewards premium features program. Right, so this is what you're talking about. We don't want to impede that from happening. The business may notify the consumer of the conflict and provide to the consumer the choice to confirm to the controller of specific privacy settings or participation in the program. So is that what we were looking for? How does this get squared?
it's a good question, maybe.
Hard to compare 3.3. As you can see, the differences between the two bills. Not only is it a different bill, I also restructured a little bit. So I hesitate to say that's right. I mean, this looks at the very least to apply to an opt-out, but I don't know if Connecticut's was matching the same intent. I just have to look at it. I have it noted for next time.
You know,
Because again, what's going to happen is whatever you all decide to pass out, I take that back to the Senate with their as passed by. So, the comparison is going to be made at some point. So it doesn't hurt to have that run through here as well. So we all know what's going on. So we were on.
How does a business, particularly a small business, implement these things? what do they need to do to set up so they can respond and respond in timely manner and all that? Is it a big lift? Is it a little lift? What kind of resources do they have? Are we requiring them all to establish an IT department?
You're a consultant.
So my guess is, if I had a business that had a loyalty program, I would be paying someone to manage that program for me, because it's not simple to begin with, right? Because you have stars, or you have, whatever thing you have. And so it would be requiring that contractor that is managing that loyalty program for you to be able to comply with this. I can't imagine, it's possible, but I can't imagine there are Vermont businesses that have loyalty programs that are running them today on their own. That's possible.
Actually,
A lot
well,
of-
I think, are we talking about like, are we talking about kind of grocery store level loyalty programs, or are we talking about like, there are cannabis companies or shops, for instance, that have like punch cards? Would that be covered?
So a punch card, you have somebody's name and a card, right? It's a physical card.
If it's a card, they don't, like,
There you go.
for instance, I know of one that does
Yeah.
not necessarily. That does not, the card is actually just branded with the store information, no names on the card. It's just, once you hit 10, you go, like coffee shops, you know?
Yep. So that's something that they don't have your data in a file. There's not, right? You have a piece of paper. That you keep in your wallet or your phone, or, whatever it is, so that you have it with you.
Right, are we defining that as a loyalty program?
Well, does it apply if there's no data? That's my question.
Right, I guess that's my question too.
So let me follow up on what you just said, because I know of a place. I interrupted you.
No, you're good, you're good.
I know of a place that does a loyalty program, but they keep a Rolodex. That's how they do. So every time I get the 10 trigger bags, I get a free trigger. And they definitely have my data on file.
And so are they doing all the other pieces, right?
I don't know. And my guess is probably not. I mean, it's in a Rolodex. So now that's a small business that's gonna have to comply, right?
Well, you would be opting out of targeted advertising, selling your data, other things that they're probably not doing, right? So if you opt out of all of that and they're not doing it anyway, what do they have to do different? Yeah.
They're not providing online. They're doing it manually.
Dave, can I just clarify, are you generally asking about, I was reading your question as like a broader, like, what are business for this whole kind of thing, like what are businesses, what's the kind of expectations that we're like setting for them?
Yeah, well, certainly the more general question, but it is triggered about these specific kinds of things. But yeah, in general,
And not being an expert, like generally speaking, so there's like a bucket of one-time things that they're gonna need to do, like generally. So like, right, like if we're saying a business that has zeroed, is not complying with Connecticut, is not complying with California, it's not complying with anybody else, and it's just Vermont, they're just doing Vermont consumers, and they need to apply, there's like, they will have like a bit in probably in a lot of cases, like they have a lift they've never experienced before. So that is like a thing. And then you have businesses that are already complying with other states' privacy laws, and they have to update their things. And then taking both those into account, there's a lot of like, if they haven't done the one-time stuff and probably as an annual kind of update thing, we're asking businesses to more or less do like a data mapping and governance of like, what are the categories of data that businesses are collecting? Where are they storing it? Like what software solutions are they using? What are on their forms that they're asking people to submit? And does that data make sense? And how sensitive is that data? So there's a little bit of a like mapping and inventory of like risks and things like that. And I'll just keep going. And then there's the privacy notice. So if they don't have a privacy notice, then they would need to have on their website something that discloses to people like, here's what we're collecting, here's why we're collecting it, here's if we're selling it, that kind of stuff. And then they need to have some kind of method in place that is like, for the consumer rights thing, a lot of what we're like going to get into is like, if somebody, how does a person, and this is usually outlined in a privacy policy, if I notice that my data is incorrect, like how do I go about trying to exercise my rights? So they need to have some kind of process in place that is like a person that's going to make a request, and how does that actually get done? And then they need to generally have an idea of like, what are the software solutions that they're relying on, and like what's in those contracts, like between them, like are the businesses they're using and relying on, well, how are they handling the data they're like sharing with them? And then depending on kind of the sensitivity of the data, if it's health data, those have like a higher risk of like, we're exploring the data protection piece. And then with all of this, a lot of that is like a one-time thing where you would like map out your data. So businesses, especially that are working nationally, have probably done this exercise because they have to comply in other states. So they like generally know, like, we take in healthcare information or we don't, or we ask people for their emails so we can serve them newsletters. Like they generally are like, we use HubSpot or we use Salesforce or we use Facebook, and we store our information in MailChimp. So there's like an initial kind of like trying to like figure out what that is. And then it's generally updating, like, what is that? There are lots of like, there's lots of consultants and there's lots of free tools. There's lots of for-cost tools. They have to do things like check what kind of trackers are on their website. Again, there's like free tools. There's free tools to do their privacy policy automatically, depending on not only Vermont's law, but also nationally. Because a lot of states say that you have to specifically call out how that state law differs from any of the others. So there's one time, and then there's ongoing of like, if they add another software vendor, they'd want to be able to like know how that software vendor is handling their thing. So there's the one-time setup, and then there's this ongoing, just like a piece of administrative doing business, getting your ducks in a row every year of like, what are we doing this year? And yeah, I don't know if that helps.
And did I hear you say that they would have to have somebody accessible to them to actually process deletion requests
Yes,
and all that, or can that also be totally automated?
Yeah. So I would say like a lot of the smaller companies, they might just have somebody who's like checking email and doing that. They might actually have a lot of customers and things like that. For the systems, especially the companies who are doing this on a regular basis and getting requests all the time, they have automated systems to process the data subject access rights requests, the DSARs. And we actually ran into this when we were trying to construct this the first time. Is like I ended up talking to a lot of compliance specialists because we got into a thing where people were like, I don't actually like 45 days. We should just do 15 days, or we should do 60 days. And they're like, wait a second, we have automated systems that do this on 45-day schedule, because a lot of the states are on a 45-day schedule. So when we start tweaking any of the kind of like, especially how a business is like, how these things function, we're actually potentially also interrupting automated systems that make this easier for businesses to comply.
I just want to follow up on that. Is there any difference in those processes between as passed by the Senate in 3.3, or is it the same kinds of things and the same requirements and all that, regardless of, shall we say, the other add-ons we put in and what have you?
I think that's a really good question. I think generally the base level are very much the same expectations, very much the same types of things that, again, if a company is starting from the ground up and has never done this before, they're going to have a lift no matter which version of this passes. I think where it gets a little bit more complicated is things like sensitive data, like what are they when they're trying to map out their data, and the protection level that they already have. Like if they have something in place, it's probably not that big of a lift to go from what they already have, especially if they're acting nationally. They're probably already complying with California, and or they could be acting internationally and are complying with GDPR. And otherwise, if they have no privacy plan, they've never done this before, they're a Vermont company, then they're gonna have a lift in both cases, because the general expectations and requirements of both bills are structurally like very similar.
Cute.
I also emailed out the NIST guidelines yesterday,
Say again.
the NIST guidelines for data protection. It should be in your inbox. It's like 6 pages that goes through like a basic small business, what you need to do for data protection according to them. Yep.
I would also add, just looking at some of the rights here in my own CRM software, it's not a big lift for me. I mean, there's check boxes and things like,
Totally,
you know, I have like MailChimp for my newsletter and I don't even, you know, I go in and, oh, there's one less person that's getting my email.
Mhm.
And as far as my CRM software, really, it's my RMM software. This will have people's computers and access to them. It has a checkbox that says, do not send any email to them. And yes, there's a delete button, which works very well.
Um,
Okay. So, yeah. So I did read through 7, that the consumer's data was processed for profiling. Question the result, be informed of the reason. Yeah, I read these already. Okay, B, exercising their rights. Consumer may exercise their rights by secure and reliable means established by the controller and described in their privacy policy. A consumer may designate another person to act on their behalf, an agent, through all 7 of those rights that the consumer has. This is all related to that, the authorized agent. 3, in the case of processing personal data of a consumer who a controller has actual knowledge or willfully disregards the child, the parent or guardian may exercise their right. Or if it's a consumer subject to a guardianship, conservatorship, or other protective arrangement, the guardian may exercise their right. Controller compliance, a controller shall comply as follows. Timeline. This is the 45-day thing that Rep. Priestley was referring to. So without undue delay, but not later than 45 days after receipt of the request, they may extend it by, you have questions?
Sorry, Rick, I just want to flag, so since the restructuring, I'm losing track of, even though it is more clear in your version, I just want to flag that 3 is, Connecticut 2025, so it's not in 2022 as far as, processing a kid's data, minors data.
The timeline, 45 days, may be extended as long as the controller informs them of the reason to extend the 45-day period. If a subdivision 2, bottom of page 27, if a controller declines to take action, they shall inform the consumer within 45 days and instructions of how to appeal that decision. And then subdivision 3, the cost of the information, free of charge once to consumer every 12 months. If there are too many requests, the controller may charge a consumer a reasonable fee. Authentication of request. So if the controller is unable to authenticate a request from A1 through 5, and that was a question earlier about why does it stop at 5?
6 and 7.
Right. Right. And I don't have an answer for you, but so 6 was the opt-out, 7 is the profiling. If
Yes.
you're,
I think so.
are you okay adding that? So it's going to be just really subsection A.
Gives the controller more flexibility.
Is that,
It gives the controller more flexibility.
yes.
Yeah, I was just confused by why they weren't included in the, but yeah, that makes sense.
Maybe I'm missing something, but
What are we adjusting, Rick? Sorry.
so this authentication, if a controller is unable to authenticate a request to exercise any of the rights afforded under A1 through 5, so that's everything but the opt-out and the profiling. Using commercially reasonable efforts, the controller shall not be required to comply with a request to initiate an action and shall provide notice to the consumer that the controller is unable to authenticate the request. So yes, it gives the controller, they can claim that they can't authenticate the request. Or it would be through all of them. And I don't know why 6 and 7 are left off, if that's intentional. I don't know.
This here, I think we would need to check with somebody, because I'm just assuming that like. It does this affect, if we're like saying like, or if somebody's opting out of cookies on a website and they're not logged in or something, would we really want people to have to log in to say who they are? I don't know. I'm just the technical piece of this. I'm not sure we're interrupting it, but yes, I should check.
Yeah, if it's not a, if it's intentional, that's my question really. Is it
Yeah.
intentionally meant to be 1 through 5?
Right, exactly.
I don't remember.
Yeah, I need to, yeah.
Put a question mark. Okay, then we go to B. A controller. Oh, maybe we have our answer. A controller. This is why you read ahead a little bit. A controller shall not be required to authenticate an opt-out request, but a controller may deny an opt-out request if the controller has a good faith, reasonable, and documented belief that the request is fraudulent. So, yeah, you don't want to have those conflict. So you now 7. Let me make sure. See if a controller denies an opt-out request because it's fraudulent. Yeah, so I would question whether if you want to keep B as is, going back to A, you don't want to include the opt-out here, but you want to include 7 profiling. That I don't know. Maybe something we can get into next time.
Okay.
All right, third-party data. A controller that has obtained personal data about a consumer from a source other than the consumer shall be deemed in compliance with their request. A3, which is the deletion request, I believe. Yes. By retaining a record of the request and the minimum data necessary for the purpose of ensuring the consumer's personal data remains deleted from their records and not using it for any other purpose pursuant to this subchapter. Misrepresentation. A controller shall not condition the exercise of a right under the section through any false. And I remember last time we're gonna strike through false and fictitious, right?
Yeah, keep the minus.
I will make it a Rep Cooper special. The use of any fraudulent or materially misleading statement or representation, or the employment of any dark pattern. Then you have the appeal section. I don't think this is anything that is super controversial about the consumer having the right to appeal. 60 days. Must have a decision within 60 days.
There is a, let's see. Just later in the appeal section when it gets to, in response to requests to exercise the consumer's rights, shall not disclose. That's, it's a little further down, but that is Connecticut 2025.
In
In the
subsection
appeals, no, just in this section, I was just saying like, it's not controversial, and then, but I wanted to flag that there is new stuff between Connecticut 2022 and 2025.
what's the line?
It might be in a different order, Rick. Oh, no, it's not. It's, It's E.
E, okay.
Or E.
Yeah, E is, yes.
Yeah, yeah. Oh, just four. E, I mean, yeah.
So this is where a controller gets a request, whether or not from the consumer, if you have my data, are you processing my data? It's sensitive data that the controller should not just release to the consumer, but they should let the consumer know, yes, we do have your social, we have your driver's license number, without actually saying, here's your number for privacy reasons. All right. Then we have the duties of controllers, the data minimization, as it's known. So, what are our thoughts on how this is laid out?
This is Connecticut 2025, but reworded to
Include California's regulations.
which 2025 also had.
Connecticut, yeah, they had a version of it which
Yeah, like
may be a bit confusing the way they structured it. Connecticut does not have they don't define the reasonable expectations of consumer. They don't have that. That's California specific. But this is fairly aligned, but yeah, not word for word what Connecticut has. Yeah. And you may remember have that chart that it's still on the website that compares the data minimization between this draft and Connecticut 2025 and California and Maryland. What was the other one? Yeah, Maryland.
And Rick, you had edits to this too, that you said as far as structure.
Next time, right, for the next draft, yes. Nothing substantive, but making it read easier.
Okay.
I'm comfortable with the version. That 3.3. I think it's it has the same. Just trying to clarify what that means.
Clarifying
Um,
California.
I can't tell you that I fully grasp what those clarifications are. I would also say that, if we can't really get our head around some of this stuff, I'm also comfortable with the AG issuing guidance about this. But again, I don't see anything defensive in concept with what we got.
Question is, it is far enough out of the realm of what Connecticut 2025 is to be off kilter. You know what I mean?
That's what I'd like to understand as well. In reading it,
Yeah. So
I don't know.
So as far as Connecticut 2025, like I said, like they were trying to basically get here. Yeah, Maroney said his mistake. He literally just tried to call me. I can put him on speaker. He will fix. Basically, no one flagged to him that he didn't, and his intent didn't actually match what he was trying to do for California. And so I think like any business that is already not having to, so any business that's complying with like scaling to a national level is going to do the strictest standard, where the California, basically in some cases, there's ambiguity around Maryland, so companies are still basing everything they're doing off of California. So national entities are already doing this, and international level entities, because this is based off, like California was essentially based off of clarifying GDPR. And then any business that isn't yet doing anything about privacy, this is the clearest standard to work from. Yeah. It is not as strict as what we had. This is this is a concession of trying to have a strong organization standard that businesses are already complying with, that is not as strict as what Maryland had. In the absence of a private right of action.
I would think that the AG is still gonna have to work on this.
They totally, but I don't think this like bars them from, they can like
No,
continue to
exactly.
add rulemaking just like California does, yeah.
There was a term there, reasonable expectations of consumers. And
That's just
one
California.
that I think the AG is, that doesn't give a whole lot. I mean, it gives some guidance, I suppose.
Number two is the reasonable expectations that are exactly copied from California.
Yeah, no, I understand, but they also have, I think, further examples, in their rule. Am I wrong?
In their guidance documents that
Yeah,
complements the privacy.
I'm just saying, I think
Yeah,
it's probably, the age is gonna have to do some more work.
they could, yeah.
Yeah. But I'm comfortable with the concepts. I just think that they're gonna have to do a lot of work. Actually, sure.
I will say that anytime we try to make things more clear and folks tell me it's less clear, then I'm happy to go back to whatever they prefer. That just. Our attempt isn't working in the direction that makes it easier, then we should not do it. That for me is.
Let's say if we go back to 2025 though, because he essentially has the equivalent of reasonable expectations that he tied to A and he didn't tie to B, and it was supposed to be tied to both A and B the way that California do. So if we were gonna go to Connecticut 2025, then in the very least, we should at least fix what he broke, which is attach the reasonable expectations to both A and B,
A and B.
which is what he would fix. We'd have to pull up Connecticut.
Oh, yeah, okay, not A and B in, I was just wondering if what you were referring to would be seen somewhere in,
Connecticut 2025, 1295.
right, the A and B in that one,
Yeah.
not an A and B within ours. Okay.
So,
I'm comfortable with the language and that helps us move this along.
whatever,
I'm looking at what's here.
What we have on the screen or?
Yeah, he's looking.
Yeah. Yeah, to me, to Monique's point, we want to make sure that just because you give consent to the data, and maybe we need to reword this, Rick.
Yep.
But just because you opt in to allow them to collect extra data doesn't mean it's a free for all.
Yeah.
Oh, you opted in, so now we collect all this stuff and do whatever we want with it. And I think that was what
Totally.
he was trying to
Totally,
fix
yeah.
with
for
that
sure.
section B, that yes, you can collect additional data with consumer consent, but you still should only collect what you minimally need.
Exactly.
I guess the question is this far enough off the rails where it makes it difficult for Vermont business that's doing business, say in the New England area, and they're already complying with Connecticut, will this make it difficult for them, or would they have to switch to this state? I don't know.
Does this create a slightly higher standard than what Connecticut is at now?
I think it does, because I think it's fixing the issue that
But ours,
Connecticut had, right?
but ours is not gonna be enacted until they're after.
Ours will be
Ours will be
18 months after theirs
Right,
is
and
even
then we
enacted.
still have to-
Yeah.
Exactly.
But then I would be concerned if we don't fix it, now they
Right.
can be a free for all.
Right.
So that's why I said, I mean, if we need to change the language, whatever, but I think the intent should, even though it's not technically like a law,
I mean, I guess, yeah, you're basically saying like, we shouldn't copy mistake if if a mistake was made and then it harms consumers, which is, I agree with. We shouldn't just copy
Connecticut.
stuff to say that we're copying it if it's broken. Yeah.
But, yeah, I mean, maybe we need to hear from the business community about how we can make that clearer.
Maybe we have. Yeah, remember a year and a half. Just fix those things if we find them.
So B, I think there's no issue with B. The problem is with Romanet I and II, right?
Yeah.
That needs to be cleaned up. So B is going to be the same as long as you all want it to stay the same. That a controller shall obtain the consumer's consent in accordance with the subchapter before processing the consumer's personal data for any purpose that does not meet the requirements set forth in A, provided the consumer may withdraw consent at any time, and further provided that methods for obtaining consent shall be easy to understand, offer symmetry and choice, not use language or interactive elements that are confusing, not use choice architecture that impairs or interferes with the consumer's ability to make a choice and be easy to execute.
I found this to be an unreasonable standard. Just in reading that sentence, that doesn't sound like something that will be easy to understand. Particularly when we have what I feel like are vague terms around choice architecture, which to me makes a broad statement about how all people make choices. I think I know what the intent of it is, kind of, but I just find myself struggling to see words that is, if this is the simplest way to state it, I submit that it is even harder to do.
So we have consent defined, right? And consent freely given, specific, informed, unambiguous of their wishes. I know you took issue with that, including by statement or clear affirmative action.
Yeah.
So, maybe you supplement, if you don't like that language, maybe we could talk about a way to match up the definition of consent, which already has these requirements in it.
I mean, like, what if the period happens a few lines earlier? Like, I'm just wondering if we're getting into,
Like, shall be easy to understand, period.
yeah, maybe that's where you take the horn out of your mouth. No more trumpet solo. Like, easy to understand, easy to execute. I mean, I think the symmetry and choice was an example, but I think was something that we were explaining yesterday is like not having one big button, a smiley face, and one tiny button with a frowny face or something like that.
It's a great example.
I mean, language and interactive elements, and is the implication that without outlining it like this, that's what we're going to continue to get? If something is easy to understand and easy to execute.
Could we possibly substitute choice architecture with dog patterns?
Oh, is that what this is saying?
We're trying to avoid, it's not an equal, no, because choice architecture is like you're choosing between yes, accept cookies and no accept cookies. Those aren't dark patterns. Dark patterns could be employed on those,
That's what I mean.
which is what, yeah.
That was what I was going to,
Mhm.
Not use dark patterns.
because I feel like oftentimes those, well, it isn't. It feels like they're often coupled.
So consent also does not include dark patterns. So again, the definition of consent is pretty,
So maybe we're being a little redundant.
I think there's probably some saying that says you make laws, 99% of people, you're not really making the laws for, right? It's 1% of people, right? So is there one business that would do this? Maybe, that they would make it tricky and this law would apply and, So I am looking at those last three lines or last four and trying to look up the definition of consent. And it is extra. The symmetry and choice is not reflected in the definition of consent. So you are further narrowing what consent is. But it's also when it comes to your consent for a certain aspect of your personal data. It's not agreeing to privacy terms, it's not agreeing to, this is, we're talking about you are consenting to processing your personal data, not sensitive data, but personal data. Anyway.
The thing I would add, I just thought of is maybe we should be obtaining or revoking. Because we may make it easier to obtain consent, but if you want to revoke, now you have to go through 1.5 million different things.
May withdraw consent at any time.
It's just thought.
Yes, the withdraw consent that
I see what you mean.
we still had, I think, revoking it.
My kids in the cell phone service, you'll see what I mean.
Asymmetry.
So the withdrawing consent, I know that's addressed somewhere in the bill, but it's not addressed here. Like that language that it should be as easy as how you gave consent does exist somewhere in the bill. I will look at that.
Oh, G has revoked on the next bit. Is that what you're getting at?
Yes, thank you. G. Shall provide an effective mechanism for a consumer to revoke their consent.
Okay.
That is at least as easy, yes.
You're fine, that's down.
That's why papers.
Probably a good choice for us to. So we have time to leave the premises before roads are shut down. So, we'll continue this discussion more after the floor. I think we can get through the rest of those. The committee again tomorrow. For those. In the morning, and hopefully we're not there all afternoon either, so.
Tell me I don't have to postpone action again.
They will tell you that in the morning.
That's tomorrow.
So we won't be meeting at 9. We're on the floor at 9:30 and then we're back in here. And remember, if we get done before in the morning, we'll continue on. If not, then it'll be in the afternoon, but we do go to the floor at 1. Question?